Good day, everyone. We are now on the week 5 of the Law on Obligations and Contracts. For today's topic, it's all about pure and conditional obligations under Section 1, Article 1179 to 1192 of the Civil Code of the Philippines. This topic will be based on Hector S. De Leon's Law on Obligations and Contracts, 12th edition.
The value of this topic is to explore the difference between pure and conditional obligations and examine the various types of conditions that can affect obligations.
According to Article 1179, obligations not depending on future or uncertain event or a past unknown event is demandable at once. Also, obligation with resolutory condition is demandable. This is what we call pure obligations. These are immediately demandable without conditions attached. For example, A obliges herself to pay B with 5,000 pesos. This is demandable because there is no conditions specified on the statement. A conditional obligation is one where the demandability depends upon a condition. This condition can be something that will happen in the future and is uncertain, or a past but unknown event referring to the knowledge to be acquired in the future of a past event unknown to the interested parties. According to Article 1183, condition must not be impossible, which is what we call physically and legally impossible, which will be tackled upon as we go on further with this topic. The example of a conditional obligation is, I will pay you 5,000 pesos if you pass the exam. The obligation of paying 5,000 depends upon on whether the condition passing the exam actually happens. There are two principal kinds of condition. First is suspensive condition, wherein its fulfillment will give rise to an obligation. The obligation's demandability is suspended until the happening of the uncertain event. For example, Anna will give CC 1,000 pesos if CC got a perfect score in the exam. That means that Anna's obligation to give 1,000 will only arise or will only happen if CC got a perfect score in the exam. Next condition is resolutory, which is the opposite of suspensive. Its fulfillment will extinguish an obligation. For example, I will let you use my laptop only until next week. The right to use my laptop is ineffective, but it will end next week. And when next week comes, the obligation is extinguished. There are three distinctions between suspensive and resolutory condition. First one is when it comes to fulfillment, in suspensive the obligation arises, while in resolutory the obligation is extinguished. If suspensive condition does not take place, the juridical or legal tie of the law does not appear, means it's not legally binding. While in resolutory, the law is consolidated before being extinguished. And when it comes to existence, in suspensive condition, the obligation is a mere hope unless the uncertain event happen. While in resolutory, the obligation is in effect and will end once the uncertain event happen. When is obligation demandable at once? First, when it is pure, which means it is immediately demandable without any conditions. Secondly, when it is subject to a resolutory condition wherein its fulfillment extinguishes an obligation. Thirdly, when it is subject to a resolutory period which means upon the arrival of a future uncertain event, the obligation is terminated, so therefore it is demandable at once. Article 1180 states that when a debtor promises to pay when his means permit him to do so, the obligation shall be deemed with a period. A period is a future uncertain event wherein upon its arrival, the obligation subject to it either arises or extinguishes. If a debtor and the creditor cannot agree to the specific time of payment, the court shall fix the payment period according to paragraph 2 of Article 1197. Other cases indicating a period is when the debtor binds himself to pay little by little, as soon as possible, from time to time, at any time I have the money, in partial payments, and when I am in a position to pay. Article 1181 tells us that in conditional obligations, everything depends on the conditions. If the condition happen, one party may acquire rights, but at the same event, it can also cause the loss of rights already acquired by the other party. For example, in the first case, T, the testator, in his last will and testament, gave some property to H, the heir, provided T would die within 2 years. In here, H will only acquire the right to the property if the condition T's death within 2 years happens. So this is an example of acquisition of rights. In the second case, X binds himself to support Y until Y graduates from college. Here, X already has the right to support, but once Y graduates, that right will end. This is an example of loss of rights already acquired. Article 1182 tells us that if the fulfillment of a condition depends only on the will of the debtor, the obligation is void. But if the condition depends on chance or on the will of a third person, the obligation is valid. One way to classify conditions is as to their effect. A suspensive condition is one that gives rise to an obligation once the condition is fulfilled. This means that the obligation is not yet demandable until the event happens. Example, X will give you 1,000 pesos if you get a perfect score in the exam. Here, the obligation to pay starts only if the condition getting a perfect score is met. The second type as to effect is the resolutory condition. This is when the obligation is valid and demandable now, but it will be extinguished once the condition happens. Example, M will give A an allowance until A graduates from college. The allowance is given now, but it will stop once A graduates. That event ends the obligation. Conditions may also be classified as to form. An express condition is stated clearly in words, while the implied condition is not directly stated but understood from the nature of the obligation. Conditions classified as to possibility could be possible condition, one that can actually happen either physically or legally, and the impossible condition, which is one that cannot happen either because it is against nature or the law. Conditions may also be classified as to mode. A positive condition consists the performance of an act, while a negative condition requires that an event must not or does not happen. As to numbers, we have conjunctive condition, which requires the fulfillment of all the events stated in several conditions. Next is this disjunctive condition, which requires the fulfillment of any one of the events stated in several conditions. So this means only or some of them must be fulfilled. As to divisibility, we have a divisible condition, which is one that can be partially fulfilled, and the indivisible condition, which must be fully fulfilled before the obligation arises. Another classification of condition is as to cause or origin. We have potestative condition, depending only on the will of one of the contracting parties. Next is casual condition, which depends on chance or on the will of a third person. Next is mixed condition, which depends partly upon chance and partly upon the will of a third person. Potestative condition is suspensive in nature, and when it depends upon the will of the debtor, conditional obligation is void. For example, I will pay you if I want. This is invalid because it depends only on the debtor's personal will. Therefore, there is no juridical tie created as well as there is no burden on the debtor's side. If the obligation is pre-existing and does not depend on the fulfillment of the potestative condition, only the condition is void. Example, D borrowed 10,000 from C, payable within 2 months. Later, D promised to pay C after D sells his car, and C agreed. Only the condition is void, but not the pre-existing obligation of D to pay C of 10,000 pesos. When a suspensive condition depends upon the will of creditor, the obligation is valid because normally the creditor is interested in the fulfillment of an obligation because it is for his benefit. For example, I will pay you my indebtedness upon your demand. If the condition is resolutory in nature, like the right to repurchase in a sale with pacto de retro, the obligation is valid. If the suspensive condition depends upon chance or upon the will of a third person, the obligation subject to it is valid. Example, where X, the building contractor, obliges himself in favor of Y, the owner, to repair at X expense any damage to the building that may be caused by any earthquake within 10 years from the date of completion of its construction. This is a casual condition because the obligation depends on an event outside the control of either X and Y. In this case, this is the earthquake. The obligation is valid because the condition, which is possible and not based solely on the will of the debtor. It only takes effect if the earthquake happens, but the promise itself is legally recognized. In mixed condition, the obligation is valid if the suspensive condition depends partly upon chance and partly upon the will of a third person. Example, X, the contractor, must repair at his own expense any earthquake damage to Y's building if arbitrators find that construction defects contributed to the damage. Both conditions must take place in order that X obligation will arise. The decision of the panel must be accepted by X and Y as a final judgment. In Article 1183, a condition must not be impossible to fulfill. If the event required by the condition cannot happen, the obligation is void. If the obligation is divisible, meaning it can be partially fulfilled, only the part not affected by the impossible condition is valid. There are two kinds of impossible condition. One is physically impossible, which are conditions that cannot be done naturally or they are non-existent. For example, I will pay you 10,000 pesos if it will not rain for 1 year in the Philippines. Legally impossible conditions are conditions contrary to the following. For example, X will give Y 1,000 pesos if Y will kill Z, which is against the law. X will give Y 1,000 pesos if Y will be the common law wife of X. This is against morals. X will give Y 1,000 pesos if Y will slap his father, which is against good customs. X will give Y 1,000 pesos if Y will publicly advocate to overthrow the government, which is against public order. X will give Y 1,000 pesos if Y will not appear as a witness against X in a criminal case, and this is against public policy. What are the effects of impossible conditions? Impossible conditions annul the obligation subject to it. Both the obligation and the condition are void. It is because the obligor knows his obligation cannot be fulfilled. So, conditional obligation is void. If the condition is negative, which is not to do impossible things, the obligation is pure and valid under paragraph 2. For example, I will sell you my land if you do not give me a talking dog. If the obligation is divisible or can be partially fulfilled, the part affected by the impossible condition is void. For example, I will give you 10,000 pesos if you sell my land and a car if you kill Pedro. The obligation to give 10,000 pesos is valid, but the obligation to give a car is void because of the impossible condition. If the obligation is pre-existing and does not depend on impossible condition, only the condition is void. For example, D borrowed 10,000 pesos from C. If C later agreed to kill X before D pays him, the condition to kill X is void but not the pre-existing obligation of D to pay C. Article 1184 refers to positive condition, meaning the event will happen at a determinate time, and upon its arrival, the obligation will be extinguished as soon as the time expires without the event taking place or as soon as the time becomes indubitable. It means that absolutely certain that the event will not take place although the time specified has not expired. To illustrate the concept of Article 1184, we have here an example. X obliges himself to give B 10,000 pesos if B will marry C before B reaches the age of 23. X is liable if B marries C before he reaches the age of 23. X is not liable if B marries C at the age of 23 or after he reaches the age of 23 because the time is specified has expired, which is before reaching the age of 23. If B dies at the age of 22 without having married C, obligation is extinguished although the time is specified has not yet expired. Article 1185 speaks of a negative condition, meaning the event will not happen at a determinate or certain time. The obligation is effective and binding from the moment the time has elapsed without taking place or from the moment it has become evident that the event cannot occur, although the time indicated has not yet elapsed. Article 1185 talks about a condition that something will not happen at a certain or given time. For example, X binds himself to give B 10,000 pesos if B is not yet married to C on December 30. X is not liable if B marries C on or before December 30. X is liable to B if on December 30, B is not married to C and if B marries C after December 30. Because in this case, the condition of not marrying C is fulfilled upon the expiration of the time, which is December 30. If C dies before December 30 without marrying B, the condition is automatically fulfilled because it's now certain B cannot marry C.
According to Article 1186, if the obligor, the one who must perform voluntarily, prevents the condition, the law treats the condition as already fulfilled. For example, imagine one tells Maria, "If you pass your driving test, I will sell you my car." If one then secretly cancels Maria's test or hides her paperwork so she can't take it, one is preventing the test from happening because he caused the failure. The law treats the condition as if it were fulfilled. One can use his own wrongdoing to escape stealing the car. There are three requisites for the application of this article. The first one is the condition is expensive. Second, the obligor actually prevents the fulfillment of the condition. And the third is he acts voluntarily. The law doesn't need the obligor to act with malice or fraud, as long as he prevents the condition on purpose. The law treats it as fulfilled. He cannot benefit from his own fault or bad faith against the obligee. For example, X agreed to give Y a 5% commission if the latter could sell the former's land at a certain price. Y found a buyer who agreed to buy at X price. But instead of allowing Y to close the deal, X blocked him and sold the land himself at a lower price. In this case, the condition for Y to earn his commission was prevented by X. Since X purposely stopped Y from completing the sale, the law considers the condition is fulfilled. Constructive fulfillment of resolutory condition. Resolutory condition means that when the condition happens, the obligation ends, and what was received must be returned. But if the debtor, the one who has to give something back, deliberately prevents the condition from happening, Article 1186 applies. The law will treat the condition as if it did not happen. For example, X allows Y to stay in his house in Manila while X is assigned in the province. Later, when X was about to be transferred back to Manila, Y convinced the company president to assign someone else instead. By doing this, Y voluntarily prevented the resolutory condition. Under Article 1190, the obligation is extinguished and Y must vacate the house. Article 1187. Let's talk about the effects of a conditional applications once the condition is fulfilled. When the condition happens, the effect goes back to the date the obligation was created. We call this retroactive effect. For example, if both parties have duties, the fruits and interests are considered cancelled out during the waiting time. If it's only one-sided, the debtor keeps the fruits and interests unless the agreement shows a different and for obligations to do or not to do, the court decides the retroactive effect. The retroactive effect of fulfillment of suspensive condition. The first one is in obligation to keep. In obligation to give, if there is a suspensive condition, the obligation becomes demandable only when the condition is fulfilled. But once the condition happens, its effect go back to the day the obligation was created. This is because a condition is only an accidental element of a contract. If the parties had known the condition would be fulfilled, they would have agreed as if it were a pure obligation from the start. So, when a suspensive condition is fulfilled, the obligation is treated as if it already existed from the beginning, not just from the day. For example, on January 20, S agreed to sell his land to B for 50,000 pesos. If B lost a court case on April 10, before the case was decided, S sold the same land to C. Later on December 4, B lost the case. Since B lost, the suspensive condition was fulfilled. By law, the effect goes back to January 20 when the obligation was first made. This means the sale to B takes priority and S should not have sold the land to C. The obligation is next one is in obligation to do or not to do. In obligation to do or not to do with a suspensive condition, courts decide the retroactive effect based on sound judgment and the party's intent, determining if and when it applies. For example, when unconditional obligation, such as the debt forgiveness upon a lawyer winning a case, is fulfilled, the debt is retroactively extinguished if that was the party's intent. For obligation to do or not to do, courts determine the extent of this retroactive effect. The retroactive effects as the fruits and interest in obligation to give. The first one is a reciprocal obligations. In reciprocal obligations, once a suspensive condition is met, fruits and interest typically have no retroactive effect. This is because they are considered mutually compensated during the waiting period, simplifying accounting for all types of fruit. In our earliest case, S agreed to sell land to B. If B lost his case, B lost on December 4, so S must deliver the land and B must pay 50,000 pesos. But S gives the fruits he got from the land before December 4, and B doesn't have to pay legal interest on the price because they are then compensated. In short, before the condition is fulfilled, the seller gives the fruits and the buyer owes no. Next one is unilateral obligation. In unilateral obligations subject to a suspensive condition, there is usually no retroactive effect. This is because unilateral obligations are often gratuitous. The debtor gives something but receiving nothing in return. So the fruits and interest during the waiting period belong to the debtor unless it's clear that the parties intended otherwise. For example, S promised to donate land to B and B lost a case. When B lost on December 4, S must deliver the land, but S gives the fruits and interest he received from January 20 to December 4, unless he had agreed to give them to. In short, unilateral obligations, the debtor keeps the fruits unless a different intentions was clearly shown. Article 1188 explains the rights of both the creditor and debtor while waiting for the suspensive condition to happen. The rights pending fulfillment of suspensive condition. The first one is rights of creditor. The creditor may file action to preserve his right before the condition is fulfilled. For example, he can stop the debtor from hiding or selling the property or have his right anointed in the registry of deeds. This also applies by analogy to obligation with a resolutory condition. Next is the rights of debtor. The debtor, on the other hand, can recover what he mistakenly paid before the condition was fulfilled. This is called solutio and debating, which means no one should be unjustly enriched at another's expense. Article 1189 tells us what happens to a team in an obligation to give while waiting for a suspensive condition. If it is lost, deteriorates, or improves, the following rules shall be observed in case of the improvement, loss, or deteriorates of the thing during pendency of the condition. The first one is if the thing is lost without the debtor's faults, the obligation is extinguished. Second one is If it is lost through debtor's fault, he must pay damages. And the third is, if it is deteriorates without the debtor's fault, the creditor bears the loss. And if it is deteriorates because of debtor's faults, the creditors may choose rescission or fulfillment plus damages. And if the thing improves naturally or by time, the creditor benefits. And the last one is, if it improves at the expense of the debtor, his rights are like those of a usufructuary. Article 1189 applies only under certain conditions. For it to apply, five things must be presented. The first is if the obligation is a real obligation, meaning to give something. Second, if the object must be specific or determinative. Third, the obligation is subject to a suspensive condition. Fourth, the condition is fulfilled. And the last one is, during the waiting period, the thing must lose, deteriorate, or improve. If all these three sides are present, then the rules of Article 1189 will cover. In civil law, there are three kinds of laws: physical laws, legal laws, and civil laws. Physical laws when the thing is destroyed. For example, a house burns down. While legal laws when the thing goes out of commerce or becomes illegal. For example, money that can no longer be used by law. And the last one is civil laws. When the thing disappears and its existence is unknown or it cannot be recovered. For example, a dog that has gone missing or a ring dropped into the sea. In short, laws can be physical, legal, or civil, and each affects the obligation differently. Article 1190 talks about what happens when a resolutory condition is fulfilled. If the purpose is to extinguish an obligation to give, both parties must return what they have received. If the thing is lost, deteriorates, or improves while in possession, the same rules in Article 1189 will apply to the one who has to return it. In short, when a resolutory condition is fulfilled, things go back to the way they were. Both parties return what they got, subject to rule on loss, deterioration, or improvement. Effects of fulfillment of resolutory condition. The first one is in obligation to give, just like what we tackled earlier in another slide. And the second one is an obligation to do or not to do. Article 1191, it gives the power to rescind obligations in reciprocal ones when one party fails to comply. The injured party has a choice: ask for fulfillment with damages or ask for rescission with damages. If fulfillment becomes impossible, rescission may still be demanded. However, rescission must respect the rights of third parties who acquired the thing in good faith. Now, let us proceed to the kinds of obligation according to the person who is obliged. The first one is unilateral obligation. Unilateral obligation is only one party has prestation. For example, donation or in a loan. After the lender gives money, the borrower must pay. While bilateral obligations, both parties have prestation. Under the bilateral obligations, we see the reciprocal and non-reciprocal obligation. Reciprocal obligation arise from the same cause. Performance depends on each other. For example, contract of sale. Seller delivers the thing, buyer pays the price. And non-reciprocal obligation. Both have duties, but not dependent on each other. For example, X borrows money from Y, and Y borrows X car. Their obligation current contracts and are not simultaneous. In short, Article 1191 applies only to reciprocal obligations where both parties depend on each other's performance, giving the right to demand fulfillment or rescission if one side fails. Now, we tackle the remedies and reciprocal obligation. There are two remedies in reciprocal obligation. The first one is choice of remedies, and the second one. So, in this slide, let us talk about the limits of the right to rescind a contract. So, the first one is resort to the courts. The injured party cannot decide on their own. Rescission must be asked from the court, which ensures both sides are heard. Then second one is court can fix a period. The court may allow a period for the defaulting party to fulfill their obligation if there's valid reason. And the third one is third party rights. If the thing involved is with a good faith third party, recession isn't allowed. And the fourth one is substantial violation. Recession applies only for serious breaches, not minor ones. For example, a few days delayed in rent payment doesn't justify it. And the last one is waiver of rights. The injured party may give up the right to resent, either implicitly or by their actions. In short, recessions isn't automatic. It's limited to serious breaches, respect court's authority, and consider other parties' rights. Rescission without judicial decree. The first one is where automatic rescission expressly stipulated. If the contract clearly says a violation cancels it, the parties can rescind it without court approval. The other party must be informed in written. If they don't object, the rescission is valid. If the other party disagrees, only the court can decide if the rescission is proper. So contracts can allow rescissions on their own, but court intervention may still be needed if there is dispute. Then the next one is where contracts still executory. When a contract is still executory, meaning both parties haven't fully performed. If one party is ready to perform but the other refuses, the ready party can declare rescission without going to court. No automatic rescission clause is needed. If the other party objects, only the court can decide whether the rescission is valid. So, even without a special clause, a willing party can rescind an executory contract, but disputes still require judicial resolution. Article 1192 deals with situations where both parties fail to fulfill their obligations. There are two scenarios. The first one is first infractor known. If one party clearly violated the contract first, the court will adjust the liability fairly, considering the later breach by the other party. And the second one is first infractor unknown. If it's unclear who breached first, the contract is considered extinguished and each party bears their own damages. No remedies are given. For example, S sold a TV to B. S failed to deliver on time, but B also delayed payment after receiving it. If S is clearly first, the court will temper S liability. If it's unclear who breached first, the contract ends and both suffer their own losses. These rules are fair because they balance responsibility when both parties fail to meet their obligations. When studying pure and conditional obligation, we learn about the meaning and difference of pure and conditional obligation, types of condition, classification of conditions, effects of condition, and the importance of each article under of this topic.